Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about what happens if you lose a couple times and you want to appeal up, and where you should appeal and what are the issues. And I'm talking primarily, let's just talk about, for example, business visas. Let's say you applied for an H-1B or an O-1 or an EB-1, whatever it happens to be, and the particular reasons don't agree with you or your attorney and you want to appeal up. So let's say first you applied to USCIS. USCIS denied the petition, and then normally for business type visas, you can go to the AAO, which is the Administrative Appeals Office, and you have 30 days. And the reality is that once they get it, the chances of them overturning it are very small, and it takes about 2 years to get a decision, and the likelihood is that it will remain as denied. So, what other alternatives are there other than going to the AAO? Well, you can actually file at the U.S. District Court, even though you didn't go all the way up to the AAO. Now, they have what's called exhausting administrative remedies before you usually get into the U.S. District Court. And normally that involves going through all the appellate processes and so forth. However, you can consider this somewhat of an exception to that, in that, let's say USCIS denies your petition. You, of course, wait 30 days for it to become final, so it is a final agency decision. Then, in actuality, you have 6 years in which to go to U.S. District Court on that particular decision. And when it gets up to the U.S. District Court, you're not going to have some essentially agency that's just going to rubber stamp the decision made by USCIS, and it's not going to take anywhere near the time. When you get to a U.S. District Court, you're getting in front of a real federal judge who will listen to the case. The U.S. attorney has to be called in. It's much more active, much quicker, and you get real arguments and real decisions. And so what happens is, a lot of times the U.S. attorney looks at whatever it is that was denied, many times will negotiate with his or her client, which is USCIS, and a resolution can be made before it even gets to the federal judge. And then if it does get to the federal judge, then you're able to try to resolve the situation through the means that you couldn't at USCIS. As we know these days, there are a lot of decisions that are coming down which are just purely wrong. The reality is, you're getting these officers who essentially believe that, the way Trump is these days, that they can deny with impunity cases that have no real reason to deny them. They're giving decisions that are not rational. They're making reasons which do not apply or don't look at the other facts of the case. So there's a lot of cases out there that are very good cases to appeal, but why go to the AAO, which is essentially going to put you in limbo for 2 years and probably going to come back with the same decision? Not that they always will, but the majority, the vast majority. So instead of that, get it up to federal court, and there you can use real arguments. You can also get the federal judge to issue a temporary restraining order. And in cases of an emergency, there's actually a 24/7 duty judge at the federal courts that can be reached at any time of the day or night, can issue a decision on an order any time of day or night. So if you happen to be escorted out or being escorted out of the country unlawfully, if ICE or immigration is not permitting you to do things which you are lawfully entitled to do, then of course the duty judge, if with the proper order, can get that stopped right away. So for the decision to go AAO or federal court, I would pick federal court in the vast majority of the times. The only reason realistically you might want to go to the AAO is if you do have a borderline case. It's not real strong, yet if you go up on appeal, if you can make some kind of meritorious arguments, and in the couple years that it takes to get the decision, perhaps a visa number will become current, perhaps another form of relief might be available, and in that case, the AAO might be better. But assuming it is a meritorious case, that it has a good chance of success, a decent chance of success, then the federal court is the way to go. So if you like the video, click like, subscribe, and more on the coming weeks. Thank you.